Okay, alright, we're going to get started. Our workshop today is on preliminary title reports. And again, if you're watching on the video, I've realized after watching a couple of these back that we've got a nice blank screen on here with a whole bunch of text that's almost impossible to see if you're watching just the video. So all of the materials that we have, and basically today there's just going to be, we're going to look at two different preliminary title reports, and we're going to make some references back to the RPA, California Residential Purchase Agreement, and those are going to be available. If you're watching the video and you're getting this from the website, the actual prelim that we're talking about and the contract that we're talking about, you can download, and you should have those in your hand because it's nearly impossible to see this stuff on the screen. So, at any rate, we're going to start talking about preliminary title reports. This is an old one. It doesn't matter. This preliminary title report is 4 or 5. Where's the date on here? Okay, preliminary title. This is actually from March 25th of 2004. It's been a while since I've taught these classes, so some of the materials are dated, but they look exactly the same today as they did 6 or 7 years ago. So, this one, let's go back to the top. This one is from Land America. And similar to what we've been talking about for the last 3 or 4 sessions, it's important you have a relationship with the agent you're working with. It's important you have a relationship with the buyer you're working with. It's important you have a relationship with the escrow officer you're working with. And it's important you have a relationship with not only your title rep, and the title rep is normally the person that you may see on a regular basis who potentially comes in and out of the office, but you also want to have a relationship with the title officer. Okay? The title officer really is the one who gets things done. The title rep is kind of the face of the company and will come in and potentially carry some docs around and, used to bring in donuts, but that doesn't really happen much anymore. So at any rate, this is from Land America Commonwealth, which actually doesn't even exist anymore. Anyway, putting that aside, we've got our title company. We've got our file number, we've got our escrow officer. Again, make that contact. If you are not in a habit of talking to them on a regular basis, it's probably because you just don't do business with them on a regular basis. Nothing wrong with shooting them an email, giving them a phone call, introducing yourself and saying, hey, you're my title officer on this deal. What can I do to help expedite it? I'm representing the buyer, I'm representing the seller. What can we do? And then quite honestly, if you really have a problem with the file, that's the person you're going to want to talk to. And it is amazing the power that these folks have to get things done and do special favors for you. This particular one, attention Patty Underwood, this is sent to our escrow officer. So normally that's how these things kind of flow. Preliminary title reports are ordered by escrow. The title company gets them to the escrow. Escrow may get them to you, or the title company may send them directly to you. But the reality is most of the contact with the title company is going to be between escrow and title, escrow and title, escrow and title. Doesn't mean you can't call them. So we've got a reference number, we've got a property. This is a Majestic Prince in Moreno Valley. This is a house I sold a few years back. And then of course we've got the cover letter. This is important. Dated as of March 25th, 2004 at 7:30 a.m. So this preliminary title report and the information contained on the preliminary title report is good as of that day. So if something comes in at 8 a.m. on March 25th, after the date of the report, guess what? It ain't going to be here. Okay? Now more than likely, all of the work on this prelim was probably completed on the prior business day, whatever documents were of record were in that particular day. But at any rate, you got to be careful. This happens all the time. It's now a week later, 2 weeks later, the day before you close escrow. Yes?
Can I ask a novice question?
Absolutely.
Sometimes I know, like especially lately, there have been a lot of delays in closing files.
Yep.
If you get a title, if you get a preliminary report like this, how long is it good for? 30 days, 60 days, 90 days?
It's good for this day.
Okay.
And that day only.
Okay.
And this is where we run into a lot of delays, and that's not a novice question, it's a fantastic question.
Thank you.
The title companies should be pulling up regular updates throughout the escrow, especially if you have a long escrow, because keep in mind, we open escrow today. Within a couple of days, escrow should order a preliminary title report. We now have a preliminary title report dated as of that day. We now have a 30-day escrow, a 60-day escrow, God forbid a 90 or 120-day escrow. That's a lot of time that can transpire between the day it was originally ordered and the day escrow closes. I mean, even though 30 days may not seem like very long, a lot of things can happen to affect title prior to close of escrow. So your good title companies will continually go through, update this information, make sure that something new hasn't popped up, and there's a variety of new things. A lien from the city, maybe a loan popped up, maybe something popped up against the buyer or the seller. Maybe they filed bankruptcy or I mean, there's a variety of things that could come up. But bottom line is, to answer the question directly, the title report is good as of the day it is issued. So if there, for example, let's suppose this title report, not suppose, this is March 25th, 2004. If we're going to close on March 28th, okay, on the day before, or more than likely the morning of, or both, to be honest with you, I'm not 100% sure what the procedures are internally, but certainly, if not the day of close of escrow, the day before close of escrow, they're going to rerun this, and they're going to see if anything has changed. And if anything has changed, which affects the actual title on the property, or money owed, taxes, some sort of a lien that's been filed, then all bets are off. Okay? You hear this a lot. You're ready to close, and then you'll get an email that says a lien popped up. Okay? And in this particular marketplace that we're experiencing right now, a lien popping up is not uncommon. Especially a lot of the bank-owned stuff. We're doing a lot of bank-owned properties, a lot of short sale properties, a lot of properties that are maybe not being maintained the way we like them to.
Yeah, a lot of code enforcement.
Code enforcement stuff.
Like
all of that stuff affects title, and once they file that notice of abatement and they file the lien or they file the notice to correct, that impacts title, and now it's going to have an impact on your escrow. So the boilerplate cover page, in effect, kind of describes what they're doing. This is in response to an application. By the way, this is not the title policy. This is basically the preliminary title. There actually is a insurance policy that gets issued at close of escrow. Okay? This is the preliminary report, basically saying, based upon this information, we are or are not prepared to issue title insurance. And then at close of escrow, it's very similar to a title policy, or not a title policy, but it's similar to an insurance policy that you would receive on your vehicle or even your fire insurance. You'll get a separate policy insuring the title to the property. But this is not the policy. This is the report that says these are the things that either are going to affect title, maybe they're going to be excluded, they're going to be exceptions. I can hear it talk about exceptions and exclusions from the policy. So at any rate, so we've got our standard boilerplate cover form. Let's get to page 1. Page 1 is by the way, these are all formatted exactly the same. Every title report, irrespective of what company you're going to get it from, is going to have a Schedule A. Okay, that's just the way they do it. They're all doing it the exact same way. And they're normally formatted the same way, and they normally actually come in the same order. So looking at title companies from 5 or 6 different companies, you're going to end up with 5 or 6 very, very similar looking reports, okay? Even in the order in which they present. Okay, so basically what their Schedule A is telling us, the form of policy of title insurance contemplated, what we're applying for, by this report is a CLTA, homeowner's policy, that's referred to as the CALTA, which is the California Land Title Association's homeowner policy. And then secondly, is a second policy that we're talking about, which, hello Carl, which is the ALTA loan policy, okay? And there's actually 2 separate pieces of insurance that we're talking about looking at right here. If you go to, and again, if you've recently taken your real estate exam, these terms probably are somewhat familiar to you. Okay, they talk about title insurance on 1 or 2 questions, I think, in the policy, or at least the state exam that I can recall. And they talk about CALTA policies and they talk about ALTA policies. But again, if you part of the reason we're doing this video presentation in this class is we want you guys to be able to answer the basic question. And the basic question is, if, by the way, again, read the preliminary title report. Because if you don't read it, your client very well may. And then they're going to call you and they're going to say, Lance, would you please explain to me on page 2, Schedule A, I'm confused. What does this CLTA homeowners policy mean? Or what does this ALT loan 1992 mean? And what you need to be able to do is you need to be able to professionally redirect them back to the purchase agreement. Okay? Or better yet, you need to refresh their memory and says, hey, remember when we filled out the contract? Again, here I am using that word again. We now have a copy of the California RPA, Residential Purchase Agreement / contract, and you want to refresh their client's memory that says, do you remember when let me get to the right spot, when we talked about when we were completing the contract before we submitted it to the seller, on page 2, under allocation of cost, item C, escrow and title, okay? We checked a couple of boxes. You know, we said buyer and seller are going to pay the escrow fees or split the escrow fees. And right below that, item C2, and this is probably what we did, because this is normally how it works in Southern California real estate. Normally, a buyer will ask the seller to pay for the owner's title insurance policy. Normally, you're going to check the seller box. Traditionally, the sellers in Southern California, which by the way, Northern California is different. What we consider normal in Southern California is not normal or usual cost in Northern California. And it's certainly different if you go to Arizona or New York. I mean, the rules are completely different. But at any rate, we're now reminding our buyer, let me go back to here. ALTA, homeowner's policy of title insurance. What we're looking for is in the contract, we asked the seller to pay for an owner's title insurance policy. That's what that is. That's the CALTA. Okay? Now also, as you're refreshing your buyer's memory, if you remember, we talked about just because we checked the box that said seller, and you see the box that says seller, and as soon as you see anything that has to do with title insurance, you automatically, if you're the buyer, says, oh, the seller's paying for all the title insurance. Well, that's not correct. At least the default of the contract in parentheses says, buyer shall pay for any title insurance policy insuring buyer's lender, unless otherwise stated in writing. Normally, again, in Southern California, the norm is seller pays for the owner's policy, buyer will pay for the lender's policy. So let's go back to the prelim. And ALTA loan 1992, that is the lender's policy. So what we are applying for are, in this particular case, 2 different pieces of title insurance as called for in the contract. On page 2, allocation of cost, item 4, C2. So you need to know this. You need to be able to connect the dots. So when you're looking at the purchase contract and you're looking at the escrow instructions and now we're looking at the preliminary title report, we know how this stuff all comes together. If for no other reason, you need to know it because that's what we do and this is our profession. But you know, as important, if a client asks you what this means, you need to be able to explain it to them and you need to be able to point them to the contract as to where it is. So this is the insurance that we're basically proposing, which by the way, we're contemplating purchasing. We may or may not be able to purchase it, depending upon what the prelim says and all the rest of this sort of stuff. So we're going to scroll down a little bit, and again, this may bring back memories of real estate licensing school, because most of the time this isn't really important to our day-to-day real estate transactions, but it's telling us this is the type of policy we're getting. Oh, and by the way, the estate or interest in the land here and after described or referenced or conveyed or covered by this report is a fee. Sound familiar? Real estate exam, fee simple, pretty much the same thing. Leasehold, that's where you don't own the land, you're leasing it.
Life estate.
Life estates, there you go. Condominium, townhomes are a little bit different. Okay, probably most of all of the real estate that we're going to sell, which is residential, is going to be sold as fee or fee simple. Basically, it means you own the house, you own the land, and you own up into the heavens. Okay. Now, this is important though. I'll give you an example. Newport Beach. There's a lot of properties in Newport Beach, at least that I'm aware of, that you drive through the neighborhood. Like, wow, okay, this is nice. Hey, this is great. Wow, I want to buy this house. You know, you write an offer, you buy the property, and guess what? It's leasehold. You don't own the land. And guess what? You bought the frame structure, and you get to make a mortgage payment on that, by the way. But at the same time, now you're paying out a land lease forever. Okay, to whatever that happens to be. Mobile home parks, very typical. A lot of mobile home parks, you don't own the land. Okay, that'll be a leasehold. Or estate for life. We'll get into all the rest of this sort of stuff. But generally speaking, it's going to be fee. Now again, you need to read. Now just think about this for a minute. Let's just pretend, let me use my Newport Beach example. We've got a seller who is oblivious. We have a listing agent who's oblivious. You have a buyer and a buyer's agent who is oblivious. You walk into this property. It's beautiful. Which, by the way, if you search properties in Newport Beach, a great example, you'll look at a property and you'll say, wow, look at this. This is fantastic. And I can buy this place for $450,000. This is an absolute steal. You go under contract. The seller and the listing agent have checked out of reality for a moment. The buyer doesn't know where they're at. The buyer's agent maybe came from Inland Empire, doesn't know where they're at, and they think that they just went under contract on a property for $450,000 near the beach in Newport. Then you get in here and you see it says leasehold, and you do a little bit more investigation, and you realize that you have, oh, in addition to the $450,000 mortgage that you just bought, you have a $4,000 a month lease payment. Okay? Now, not very common for Inland Empire, and quite honestly not very common for most real estate that we're going to be dealing with, but you need to know where you're at. Okay, so this is just describing the type of estate or interest in the land that we've got, pretty straightforward. Title and estate or interest currently is vested in, this should be your seller's name. Okay? Now, we've done a lot of talking so far in our classes about you need to know who your buyer is. Okay? You need to know their first name, their last name, their middle initial, their full middle name. Are they single? Are they married? Are they divorced? You want to know all that information, because if you don't have it right, you're going to have to correct it later and it's going to cause you a problem. Now, the same thing holds true when you go out and take a listing. Okay? When I go out and take a listing, I want to know who my seller is. Okay? And not only do I want to know make this not blue. There we go. Not only do I want to know their names, I want to make sure I have everybody that is on title. This has happened to me. If you've been doing this business for any extended period of time, it'll happen to you. You'll take a listing. You think that you're dealing with Mr. and Mrs. homeowner, and then all of a sudden you get a preliminary title report and you realize, oh, it's Mr. and Mrs. homeowner and maybe their parents or somebody else. Okay? Well, guess who needs to sign off on this grant deed? Well, we got to get all of them. Okay? And oh, that's fine, Lance. I see it on the. I run a property profile. Well, unless you actually have a copy of the original deed, and this happened to me more than once. You get a copy of the original deed, and it will have everybody's name listed, assuming it's the original. But what if there's been a quitclaim, or they've added some people, they've removed some people? Okay. But if you just look at the cover letter on the property profile, or maybe if you go into realist tax, sometimes there's only this much space to put in the names of the owners. and they ran out of space, and they had 4 other people. But the space just so happened to perfectly end with John Smith, Mary Smith, Sally Smith. So you think you had 3 people. Well, guess what? It went on with 5 other Smiths. So if you are the listing agent primarily, take a peek at this. Make sure that the people that you believe are your sellers, and by the way, if this is the first time you're checking it out, shame on you. But if you haven't checked it out to this point, make sure your sellers are who they think they are, who you think they are. Make sure you don't have an extra one. Okay? All right, so now we've, like I said, we started off with our schedule. Go back up here. I'm going to try to go back up here. Okay, we started off with our Schedule A. Now we're going to go to, get my computer to work. Okay, we're going to go to Exhibit A. Exhibit A, not to be confused with Schedule A. Okay, the schedule normally says this is the type of insurance I'm buying, these are my sellers, this is the type of land we have. Exhibit A normally is your legal description. Okay, the legal description should match the legal description that's in your escrow instructions. All right? Now there's a lot of people in theory that should be checking this out, but you need to check it out as well. If you rewind the tape and you go to our escrow instruction class, within the escrow instructions, it gave us a legal description, the lot, tract, block, and all the rest of that sort of stuff. This needs to match. Okay, make sure we're selling the right parcel. Okay, so normally that's the only thing contained on Exhibit A. Then from Exhibit A, we go to Schedule B. We had a Schedule A, now we got a Schedule B. Schedule B will always have the same information, just like Schedule A had the information we already discussed. It doesn't matter what the title company you're dealing with is. It'll always be the same, or at least the formatting will be the same. So on our Schedule B, normally the very first thing that they talk about, what are the things we can't avoid? Death and taxes? Okay, well, the very first thing that they're going to talk about are taxes. Okay? Taxes always take priority as it relates to liens on the property, so title companies figure, well, what the heck, let's put them first. So these are the items that, and again, so far they're saying at the date hereof, which is the date of the preliminary title report, or the prelim, the current exceptions to the coverage, in addition to the printed exceptions, yada, 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 are as follows. So right now the title company is already saying we're going to make some exclusions to the insurance. Okay? And as of today, the exclusions are going to be property taxes. Okay? And it lays out all property taxes, you have the ability to make 2 installment payments. Your December 15th and April 15th installment payments on your property taxes. First installment is the December 15th installment. The second installment is the April installment. On this particular, and it'll list both, and on this particular one, it says that the first installment has been paid. Okay? So that's great. Okay? The second installment, based upon the preliminary title report that's been run, is open, in effect, unpaid. And this amount is valid until April 10th, after which penalties will apply. Okay? If you don't have it, then you're going to have penalties. Now you run into this a lot where you will have a seller, now I'll put my listing agent hat on, you will have a seller that says, well, they're paid. Okay? Prove it. Okay? If you paid your first and or second installment of taxes, then escrow and title is going to need proof. They're going to need a receipt, and putting this receipt aside, they're going to need to confirm it with whatever county that we're dealing with. Okay? These will need to be satisfied at close of escrow, prior to close of escrow, as part of the settlement. Okay? So we've got our taxes that need to be dealt with, and so then again, that'll always appear. Then we go down to supplemental or escaped assessments of property taxes, if any, assessed pursuant to the Revenue and Taxation Code. So is there possibly a supplemental tax? Well, there could be. We talked about this in a couple of other classes. Supplemental taxes can be for a variety of things. Examples we used earlier were school districts, lighting assessments, street lights, landscaping assessments, the off-ramp to come off the freeway, Mello-Roos. Okay, we could do a 2-hour training class on Mello-Roos special assessments. Okay, But you've got to be prepared for that. And quite honestly, if there are Mello-Roos special assessment, it doesn't always say, oh, by the way, Mello-Roos. By saying supplemental, if any, that could mean Mello-Roos. So we're going to have to make sure our title officer is checking into those things for us and letting know if there are Mello-Roos taxes, how much are they and how much longer do they have left. A quick lesson in Mello-Roos, it's very common in the Inland Empire. We have subdivisions all over the place with Mello-Roos. And there is, let me use my off-ramp example, okay? A developer goes into a community and says, we're going to build 1,000 houses over here. The city comes out and says, great, we're going to permit you to build 1,000 houses, but because you just built 1,000 houses here, we're going to need to add some traffic control. We're going to need a new off-ramp for the freeway. Well, guess who gets to pay for all that? In a normal market, the developer does. The developer says, the city comes out and says, okay, if you're going to develop homes in our community, you've got to put in the streets and the lighting and the this and maybe a school, and now you've got to put the off-ramp in. So normally developers in the old days, they would factor all of that into the process. They would pay for the off-ramp and put in the streets and put in the lights and put all the rest of this sort of stuff in. And then it basically would be built into the price of the house. So now when they were selling that house for $200,000, they said, well, it cost us so many $1 million to do all of these improvements divided by 1,000 houses. We're going to now sell this house for $220,000 or whatever it happened to be. And they would recover the cost of doing all those improvements. Mello-Roos came along, which by the way, I don't know their first names, but Mello-Roos are people, okay? John Mello and Sam Roos, I don't know if that's their first name, but these basically were legislators who passed a law that said it was legal for developers to basically finance all of those front-end costs, the off-ramp and the streets and all the rest of that, in the form of bonds, Mello-Roos bonds. Okay? They now finance all of those improvements in the form of bonds. They don't have to pay for them in advance. They finance them, and then they take those bonds need to be paid off normally over 30 years. So now they do a special or supplemental assessment on each individual lot of those 1,000 houses they built, and they say your portion of the payment to pay off the 30-year bond is X amount of bucks. Okay? And guess what? Until those bonds are paid, in addition to the regular property taxes, you now have a Mello-Roos bond assessment that needs to be paid. Now, the theory was, if you remember my example, is the developer said, you know, if I paid for them in advance, I have to sell the house for $225,000 as opposed to $200,000. Well, guess how much, after this was all got passed, guess how much the developers were selling the houses for anyway? $225,000. Okay, and they pass the cost on to the consumer, and then the consumer now gets to pay this over time for 30 years. And a smart consumer, depending upon the neighborhood and depending upon how much the Mello-Roos taxes are, a smart buyer may shy away from a development that has Mello-Roos. And the sad truth is, I can name a dozen communities locally that have Mello-Roos assessments on them. The community literally the street over, same exact house for all intents and purposes, does not have a Mello-Roos special assessment bond attached to it. And they don't have the extra payment. So in theory, which property should be worth a little bit more? The properties without the Mello-Roos bonds on it.
Right.
Because those people don't have that extra payment. So, is that important? Is it important to know if you are selling and or as the listing agent or selling as the buyer's agent, is the property in a Mello-Roos district? It's absolutely important. And not only is it important to know up front, this is the type of thing that blows deals up all the time. The lender pre-approved the buyer at a certain loan amount, at a certain payment based upon their income, down payment, so on and so forth. Now all of a sudden we introduce into the transaction an additional, these are basically the equivalent of a monthly payment. We now introduce an additional payment obligation for the buyer. And by the way, some of these Mello-Roos assessment tax are $3,000, $4,000, $5,000 a year for 30 years. So you could, in theory, have a buyer who's expecting a payment of $1,500 a month and has been principal, interest, taxes, and insurance. The lender has them squeaky tight but qualified for $1,500 a month. We have not done our homework in advance. We now realize that we have special assessment Mello-Roos taxes, and that makes the payment go up $200 a month. Well, guess what? This buyer no longer qualifies.
Yeah, they're blown out of the water.
Blown out of the water. So again, do your homework. And quite honestly, if you're discovering that the property has Mello-Roos taxes or other special assessment taxes, and if you're discovering this by accident after the contract's written, after it's accepted, after escrow is open, and now you're reading the prelim, you're probably in for a problem. Because that's a problem. And even if it's only $50 a month, okay? You're going to have buyers that may say, well, what is this? I don't want to pay this. And these bonds go on for years. Again, it's
especially with the way people's budgets are today.
Absolutely.
I mean, an extra $50 can kill them.
Absolutely.
Yeah.
Okay, so we've gone through our taxes basically. Now we've got a whole bunch of items that are listed. Number one, water rights claims. Water rights claims or title to water, whether or not shown on public records. So what this is, again, we're talking about some exclusions, some exceptions, okay, to the title insurance policy. So what the title insurance company is saying is, hey, we're excluding water rights, claims to the water, whether or not they're shown on the public record. So depending upon what you're selling, if your buyer is expecting to be able to go pull water out of the river that flows next to their property, if this is what their prelim says, they don't have the ability to go throw a pump in the river and pump the water out. Now again, for most of us, we're selling single family lots, 5,000 square foot lots, 10,000 square foot lots, and we have city water, so it's not a big deal. But if you're selling rural property, certainly if you're selling property that abuts to a river, well, you better find out. Do you have the ability to throw a hose in there and water your plants? Or if you're selling rural property and the expectation is that you're going to drill a well, can you drill a well? There's properties up here less than 3 miles from this building that have the only water they have is well water. Well, in that particular case, their title report had better say they have the ability to claim that water. So in this particular case, no water rights. Okay, this is the typical stuff that you see in prelims that quite honestly we glaze over. Okay, there is an easement. In this particular case, Southern California easement. These become so common, again, we glaze over. Oh, there's an easement from SoCal, there's some blah, blah, blah. Okay? I get that, but you need to take a half a second and take a look at, in this particular case, the easement from Southern California Edison is within 6 feet of the front of the property, also within 4 feet of all side lot. Okay, so Edison says I've got access to the first 6 feet and I got access to both sides 4 feet. If I'm reading this correctly, Edison says don't worry about the back of the property line. Now again, we used an example in the escrow class about a buyer that says I want to do something with this property. Well, if what that buyer wants to do to the property pertains to the first 6 feet and the 4 feet on either side, they're probably not going to be able to do that.
Swimming pool.
The swimming pool is the example. Okay, we used in a prior class. So I have seen swimming pools. I don't know how they got a permit from the city, but I have seen, literally I've seen swimming pools where the coping side of the pool literally is right next to the fence, on the property line. Okay? And I scratch my head because quite honestly, this type of easement for a utility easement, gas, electric, water, cable, this is pretty common. you know, 6 feet in the front, 4 feet. I mean, they have trenches, they have stuff they got to do, whatever it happens to be. But if your plan was to put in a swimming pool, and if you needed that footage, you can't do it. Or hey, I want to put my barn over there for my horses, or I want to put a shed, or I want to build an extra garage. You need to read this. Very important. And again, the example that we use, if you specifically have a client that you know for a fact they are buying this house and they have told you prior to writing the offer, we are going to put a barn right there and our swimming pool right there, and if you know, you got a problem. And quite honestly, you want to have that conversation with them right then and there. You want to say, okay, I'm with you, but I'll tell you what, before we even go down this path, before we write the offer and get to this point, let me do some investigation. Let me make sure that we don't have some setback issues. And when I say setback, don't confuse a setback with an easement. Setbacks are normally terms that are referred to by the city. City governments say you have setbacks from the property lines, you can't do certain things. Completely different deal than what an easement is. Okay? An easement is not the same as a setback, although they kind of describe the same type of thing. So anyway, we have an easement from Edison. Now again, we have another easement from Edison. It almost looks like exactly the same thing, and I'll point this out because this happens a lot with different items on a prelim. This is basically the same easement. However, for whatever reason, on October 13th, 1987, an instrument, when this is an instrument number, that's basically a document number. A document was recorded, in this case Riverside County Recorder's Office, and it was given as a number. Every document that's recorded is given an instrument number. Okay? And for whatever reason, they recorded it twice. Okay? Says basically the exact same thing, at least if my reading of that is correct. Item 2 and item 3 on the prelim basically say the same thing. But they were recorded twice. Now maybe that was an error. Maybe the people with Edison had the documents and they said, well, here it is, and someone behind them had the same thing and recorded it later. But anyway, the bottom line, once something like this is recorded, it's there forever. Okay? So don't get hung up on this. Oh, wait a minute, what's going on? It's on here twice. You need to remove one of these. If it had the same instrument number, then frankly, if it had the same instrument number, then whoever prepared the preliminary title report would have made a mistake, because it should only appear once. But if it has two separate distinct instrument numbers, it's going to show up twice. So again, we have an Edison lien. Very common, very standard. We also have a lien from General Telephone Company of California, which to my knowledge, General Telephone, GTE, doesn't really exist anymore. Doesn't matter. Okay? They did exist on November 18th of 1987, and they filed an instrument number 329573, and they have a 3 feet inside of all lines. Okay? Official records within 3 feet of all side lot lines except such lines as coincide with boundary lines of street. I'm not really sure what that means. I think if I was to analyze that right now, it's not all lines, it's both sides, the right side and the left side. Okay? But guess what? It falls within the 4 feet that Edison have. So guess what? Edison and the phone company, electric and phone, are sharing an easement. They both have an easement to come in and do their thing. All right. Now, if it's not clear, and I said I wasn't really 100% sure, if you're concerned, what does side lot lines means? Well, what side are we talking about? Okay. Well, we've got the front, obviously, you got the back, so the sides seem to meet the sides. But if you have a client that says, I want to build something and I want it to go right up against the back property line, you probably want to have that conversation with the title officer, just to be clear that your definition of a side lot line is the same as what you think their definition of the side lot line, and does that mean the back line? Now, clear interpretation of the English language would mean no, that doesn't include the back lot line, but you know what? I probably won't ask. So at any rate, GE's got a lien, or not, excuse me, not a lien, an easement. Okay, number 5, covenants, conditions, and restrictions as set forth in the document recorded. Okay? November 28th, 1988, somebody recorded CC&Rs. Okay? Does that mean that the property is in a homeowners association? We talked about this in a prior class. The answer based upon what we have in front of us is, I don't know. I don't know if it's in a homeowners association. All I know based upon this is that there's CC&Rs. So give me the CC&Rs. Let me take a look at the CC&Rs. Then we need to look at the actual documents, which, by the way, all CC&Rs are recorded. So if there are CC&Rs that affect a property, they will be recorded, hence they have an instrument number. Bylaws, by the way, to kind of go back to the HOA stuff, homeowners association bylaws are not recorded. Okay? CC&Rs are recorded, bylaws are not. But you would want to get a copy of these CC&Rs, read them, and within the CC&Rs it should be clear if the CC&Rs are documents that pertain to a homeowners association. Okay, we talked about this in a prior class. Not all properties that have CC&Rs are located within homeowners associations. However, all properties that are in a homeowners association have CC&Rs. So play that back if you're not quite clear with that, but you need to read them, and it should be clear. And if it's not clear, after you get the CC&Rs, and it's not clear to you whether the property is located in a homeowners association, you need to make some further inquiries. Okay? And not necessarily just with the owner or the agents, maybe with title. You know, you need to go further. Is it listing some people in here? Are there some places I can contact to determine what's going on here? Who has the authority to enforce these CC&Rs? Okay? Which, by the way, if it's not a homeowners association, normally the authority to enforce them lies within a city. Okay? So the city would have the ability, if the CC&Rs say you cannot paint your house purple, and there is no homeowners association to govern that, one of the other homeowners would have to pull up the CC&Rs, maybe file a complaint with code enforcement and say, hey, this person is violating the CC&Rs, and the city may or may not enforce that. That other homeowner may have to sue that homeowner. So say, you're violating our CC&Rs. Go take them to the small claims court and have a judge enforce those CC&Rs. Which is why CC&Rs, to be honest with you, as well-intended as they may be, sometimes they create more problems than they solve. Yes?
I had a question. We had a property recently, about 6 months ago. They had been, it's not Moreno Valley, it was in like Menifee. They were paying into a homeowners association.
Yep.
And then they told us that the homeowners association went like belly up.
Okay.
It dissolved. I don't.
Very
we never
difficult.
saw anything that said it officially dissolved,
Right.
like a notice or anything.
Yep.
We asked them for a notice. They said, no, we didn't get any notice,
Right.
but you know we were told by people the homeowners association is out of business.
Scary.
So they stopped making their homeowners association payments.
Yep.
And the thing that worries me is that they may have missed something, and that, you know, when we get to closing, because now it's in a short sale,
Yep.
something's going to pop up, like what you just said. If it's not from the homeowners association, maybe the city is
Right.
going to lean in.
I
or
would
something.
be very, this escrow is not closed yet?
No.
Okay. Don't you dare close it until we talk offline. But
Okay.
the online conversation we'll have for purposes of this class that would terrify me. First of all, homeowners associations are nearly impossible to dissolve. Once you've rung that bell is rung and that bell is in place. And partially the reason they're nearly impossible to dissolve is, well, think of it this way. You have several different types of homeowners association, but the traditional condo complex, impossible to dissolve a homeowners association within a condo complex because you have common area all over the place. You have common driveways and maybe a pool and a clubhouse and common walls and all the rest of that sort of stuff. So dissolving that type of association, whether they're solvent or not, it's not going to happen. Okay? Probably the only way you could ever do that is if one person came into that homeowners association and bought every single condo. So now that homeowners association was basically owned by one homeowner. And even in that case, they would have to go to the city, they would have to get the plans redone, they'd have all these things that would have to be done. I'm telling you, as close to impossible as anything you're ever going to do. Now, another common type of homeowners association is more of a master plan community, okay? Single family houses, so on and so forth.
This is more like that. It's like a golf club.
But even with those, you normally have some sort of you have a golf club, you maybe have some parkways, you have some landscaping, whatever it happens to be. Well, who's now going to take care of that stuff? Who is now going to insure that stuff? If you have, okay, there's 100 homes that are surround a little mini golf club. We want to get rid of the association. Okay, well, what are you going to do with the club? Who's going to now maintain the grass over there? Who's going to insure it? Now somebody walks along there, they trip and break their leg. Well, the homeowners association owns it, maintains it, insures it. Well, now who's going to take that association's place? Is the city going to step in and say, sure, we'll do it? No, I'm not going to do it. So I would be terrified is an overstatement. You need to look into that. Highly unlikely that the association's been dissolved. And you will have homeowners within that homeowners association who aren't paying, who want to get it dissolved, will be happy to tell you that, oh yeah, sure, we haven't made our payments in 4 years, don't worry about it. Well, worry about it. Big trouble. Okay, you got the CC&Rs. This is very common. Anything that says any reference at all to race, religion, sexual orientation, handicap, familiar status, national origin, yada, 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 all of those ugly things, those are omitted. Keep it in mind, once it's recorded, it's always recorded. You can't go undo the ugliness, okay? So if there's something within CC&Rs or a grant deed or some sort of a restriction that was recorded back in the 20s or 30s or 50s or whenever, and if it says you cannot sell this person this particular property because of all of this stuff, it will still be a public record. It can be very offensive, and you need to prepare a client for that. If you're selling, just put yourself in the situation where you have one of the mentioned protected classes where you're representing them as a buyer. Maybe they're buying in, and by the way, this doesn't just pertain to CC&Rs. This can pertain to a deed or a deed restriction. And now they're buying this house that's 75 years old. They get a copy of the prelim, they get a copy of these CC&R, or these documents, and it specifically says that that person is not allowed to buy this house because of race, religion, sex, color, blah, 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 blah. Okay, all of that's omitted, but it can be real offensive. I've seen some of these documents. It's amazing how far our country has come in even 50 years. But all right, this is standard. You will see this in every single document, and if you do see one of those documents, just understand, well, that doesn't work anymore. That doesn't work anymore. Okay, said covenants and restrictions provided that our violation shall not defeat the lien of any mortgage. Okay, this is important. If there are covenants, conditions, and restrictions, CC&Rs, and they provide that a violation of the CC&Rs are in a superior position to a mortgage or a deed of trust, that's not valid. So the example would be is it's a homeowners association, and the association says you're not allowed to park on the grass. You park on the grass. The association now gives you a violation notice and fines you $100. You do not pay the $100. They then take that $100 fine and they turn it into a lien. What this says is if there is a lien for the $100 fine or the unpaid association dues or whatever, those liens do not take precedent over any mortgage. They are subordinate to the mortgage. The reason that that's important is if that clause was not in there, lenders would not lend to any properties located in a homeowners association, because they would always be in jeopardy of being kicked into second place. Lenders are okay being subordinate to property taxes. That's it. They're not okay being subordinate to homeowners association dues or homeowners association liens. Even if that's what the CC&Rs say. If they say they have priority, they don't have priority. And that's what they're referring to here. Okay, among other things, said document provides for easements over a portion of the land. So what this is saying is that the CC&Rs provide for an easement. It doesn't tell us here what the easement is. Where do we got to find what the easement is? We've got to get a copy of the CC&Rs. And we have to go to that page that refers to easements. We've already talked about a couple of easements, a few feet in the front, a few feet on the side. Maybe the association has an easement that's contained in the CC&Rs that say the rear property line 40 feet. Okay? So guess what? You got to read the CC&Rs. It's absolutely mandatory. Okay, what else have we got? Said covenant to provide the violation should not defeat. Okay, we already talked about that. That's kind of a duplicate. Okay, now we get into what the normal stuff that we tend to see. Item 6 on this particular prelim. A deed of trust to secure indebtedness. That's a loan in the amount shown below. And any other obligations secured thereby. So what this says is that there's a $120,000 deed of trust that was recorded. No, scratch that. That has a date of October 6th of 2001. So a deed of trust was prepared and dated on October 6th. The trustor, and again, go back to your real estate licensing exam. Okay, this is where all these things kind of come together. Okay, so if this is one of your first transactions and you remember trustor, trustee, beneficiary, well, guess what? There's actually, here they are. This is what they're talking about. The trustor should be your owner. So if you're the listing agent, that should say who your seller is. They're the trustor. The trustee could be a bunch of different people. Okay? Normally, beneficiaries, which is the mortgage company, and then let's skip ahead. The beneficiary of the loan is GMAC Mortgage. Okay? The GMAC Mortgage has said for all of the loans that they give out, they have assigned as their trustee, normally it's kind of a legal entity, they got the lawyer firm, so to speak, Executive Trustee Services, Inc. Okay? So, GMAC Mortgage gave a loan to the trustor, Mr. and Mrs. Owner, and the trustee is executive. The Executive Trustee Services would be the people that would start the foreclosure in the event we were not making the payment to GMAC Mortgage. Okay? So at any rate, oops. So now, here we are. We've got a loan for $120,000 that's dated October 6th. It has our seller's name on it. Sounds good. We've got a trustee. We've got a beneficiary. Oh, and then it also says, by the way, it was recorded on November 6th. And again, here we go with that instrument number again. Yes?
Technical question.
Yep.
I've been hearing a lot of stuff in the news about the mortgage mess and everything. And
yep.
When they refer to servicing companies, that would be like Executive Trustee Services, right?
Correct.
Trustee company here.
Yep.
Okay, thank you.
Yep. Could be, or it could be the beneficiary. Well, the servicing company, like for example, let's say B of A. B of A services a lot of their own loans. Okay, so the lender beneficiary could be B of A. The trustee could be, B of A Trustee Services. The servicer of that loan could be Bank of America Servicing. Or it could be ABC Servicing. Okay? And a lot of times the servicing changes all the time. Okay? The whole loan package changes. You take a loan out today with Bank of America. A week after you close your escrow, you get a letter that says your loan has been sold. Or the servicing has been sold. They could sell it to Wells Fargo. Unlikely, but they could. Or they could sell the service. So all of this can change, and the actual trustee itself has all sorts of language in it that basically says the beneficiary, you can't change the terms, of course. You can't change the terms of the loan. But it says we could sell the loan, we could sell the servicing, we could swap it around, we could do all sorts of funky things with it. So now getting back to the dates, and this is very common. The trustee, the trust deed of trust, same thing, trust deed of trust, was signed by the seller and dated October 6th, but for whatever reason, the loan did not record and fund until a month later. Okay? So you're going to see conflicting dates all the time, and that's not really a conflict. It's just, you just kind of got to think of the progression of a transaction. You know, people sign documents on one day. That doesn't necessarily matter. In fact, it's very rare that they would sign a document and then have it recorded on the exact same day. Normally, there's going to be some lag time. Okay? So, now one thing to keep in mind, and we're going to show you a different example of a different prelim, but one thing to keep in mind, the $120,000 that it mentions on the prelim, that is not the payoff amount. That is not how much money is owed on this property. That is the face amount of the deed of trust. So that's how much they borrowed. Now, depending upon the type of loan, they may very well have paid off some principal. Maybe it's a negative amortization loan. They actually could owe more than 120. Maybe they haven't been making their payments for 2 or 3 years. They could owe a lot more than 120. But don't confuse the amount of the money on the prelim with the payoff. Now I will tell you, again, this one's a pretty straightforward one, but let's suppose you sat down with the seller as the listing agent and you're working up a net sheet for them, and then they're like, hey, yeah, we bought the house in 2001, or we refied it in 2001, and this is where we're at, and this is what we're doing. And you're saying, well, great, how much is your loan? They don't have a statement available to you. You know, it's nice to get the statement from GMAC that says, hey, here's your most recent statement. Let's suppose they don't have that. And let's suppose they say, oh, yeah, we have a loan for $80,000. So you're working up a net sheet based upon an $80,000 loan, no other loans, and now all of a sudden you see this. Red flag? Absolutely red flag. Does this happen all the time? This happens all the time. Which is one reason, as a general practice, if you are the listing agent, you want to get a copy of their most recent mortgage statement. So, and then keep that, so then when you get a copy of the prelim, does that make sense? Okay, and let's assume that these people are not a short sale, they're not in default, let's assume they've been making payments, let's assume that the loan is a couple years old. If it says they took out a loan for 120, and their bank statement, most recent mortgage statement, says they have a loan balance of $118,000, well, that makes sense, right? So if those numbers are way off, then you need to stop and say, wait a minute. Now, it doesn't show up on this example, but let's suppose there was a second loan here. Okay, item number 7, an additional $50,000 second trust deed. Okay. Well, if your seller has not told you, oh, by the way, I have 2 loans. I have a first with GMAC for about 120 and a second with, Chase for 50. Do you have a problem? Yes, you do. And depending upon who that second belongs to, you may have a big, big problem. I'm going to show you another prelim here in a minute with some more stuff on it. But this is basically the end of Schedule B, which, again, very typical. We've got our loan. We've got mention of CC&Rs, we've got some utility easements, and we've got our taxes. Very common, okay? Now, let's go back to the end of Schedule B, and, okay, requirements for this section. The company, that's the title company, will require a statement of information from all parties named below, which in this case the parties named below are the buyers and sellers. They don't have them specifically named. In order to complete the report, in other words, they're telling you right now the report is not complete. And based upon the effect of the documents, proceedings, liens, decrees, or other matters which do not specify, blah, 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 it may or may not affect whether we're going to issue title insurance. Now, I don't know if I have a copy of a statement of information. Let me see. I haven't done this class in a long time, so I don't think I'm completely prepared for this. It doesn't look like I do. Okay, well, let's see how quickly our internet connection works. Let's see if we can do a Google search here for Statement of information, and that could be, this is probably going to come from the, let's make this more specific. Statement of information, escrow statement of information from, let's see if that gives us what, this is from guarantee title / escrow. Let's see if this gives us what we want. I like it. It's been a while since I've taught a class. 30 seconds later on the internet, with the joy of the internet, I got something here. Okay, now this one is from Guarantee Title. And this, every single, and they'll look similar, could look a little bit different. But every single escrow that you will ever open and close, the escrow company will provide a statement of information that has to be filled out by all parties buying, and a statement of information that has to be filled out by all of the sellers. A lot of times, I confess to this, it's such a nuisance, okay? But I'm telling you, as you can tell on the prelim, because here it is, prelim says, you're not going to get title insurance without it. So fill it out, and I'm telling you, the sooner you fill it out, the better. And this also pertains to dealing with your buyers and sellers. The sooner you get this information, the better. Basic stuff. Who am I? Why do they want to know where I was born? Why do they want to know my birthday? Why do they want to know my social, my driver's license? Am I single? Am I married? Do I have a domestic partner? Why do they want to know that? Let's make it even worse. Why do they want to know the name of my former spouse or domestic partner? That's none of their business. Well, do you want a title insurance policy or not? Why do they want to know if they're dead or they're divorced? Why do they want to know when they died or when I got divorced? Why do they want to know if I've ever filed bankruptcy? Why do they want to know where I've lived for the last 10 years? Okay? Why do they want to know where I've worked for the last 10 years? If you've ever had to sit down with a client and help them fill this out, they hate it, especially if they're sitting down there with their new wife or their new husband, and sometimes people aren't as comfortable with that as they otherwise maybe should or could be. And you have to sit back and say, yeah, I was married to Sally, and you got the new wife sitting there, and yeah, I was divorced, and so, and the new wife is like, what? Why? We're trying to buy a house. We're getting a fresh start. Why do we have to talk about Sally right now? Okay. Well, the answer to where have I lived? You know. And by the way, this is honest. We don't make any of this stuff. All of my examples are true life. Okay. When you have, I have had clients. Can we give me the signal? Okay. Do I have to put where I've lived in the last 10 years? Yeah. What's the problem? Well, because I haven't maybe been completely truthful with my new wife. Well, I don't know what to tell you, man. You got to figure this out. Anyway, the answer as to why they ask for all this information has nothing to do with them just being nosy. Okay, it has nothing to do with that at all. This is what they want to do. When we go back to the prelim, let's just pretend. Well, we don't have an item here that's really a good example. But let's just pretend for a moment that some sort of a personal lien shows up on a buyer or a seller, or any one of the principals in the transaction. The theory is, okay, there was a student loan that's gone to lien against Mr. Seller, and it was originated in Buffalo, New York, in December of 1998. Okay. The concept is the title officer goes and takes a look at Mr. Seller. Where were you living anywhere in the Buffalo, New York area in that time frame? Are you of the proper age? Could this even possibly be? Because do people have the same names? This is another thing. be prepared for. If you have clients with very common names, oh my God, this is even more important. I mean, God forbid you get the Robert Smith, okay, or the John Jones, or the Mike Johnsons, okay. You got a real common name. This is even more important, because are there a lot of people out there with similar names that have liens all over the place? Okay. Well, this is one of the things that title company does. The title company takes a look at this information. They take their statement of information, and then if something does pop up, then they sit back and they have to clear that. They have, because they're going to be the ones that are going to insure it. So if there is a legal claim, a small claims judgment against John Jones for $5,000. By the way, let's keep in mind, when we go back to the title insurance policy, the title insurance policy is basically insuring the property, right? Okay? But if there are personal judgments against the seller or a buyer, someone could come up and make a claim. Okay, that's why all this stuff needs to get on your credit report. If I sue a buyer for $5,000 for a rental situation that's gone bad, I get a judgment against them, and now I've got something on their credit. So then 10 years later they try to go buy a house. What pops up on their credit? What's the lender? The lender's going to say what? Pay this guy.
Yeah.
You need to pay this guy the $5,000. Oh, it was 10 years ago. It was from a rental. You know, pay him. Get this thing cleared up. Get it satisfied. You're not going to buy your house. Okay. But anyway, the statement of information, as talked about, and again, it's a nuisance. I hate them. I absolutely hate filling these things out. I hate having my clients fill them out. And again, specifically for some of the reasons we mentioned. It can be uncomfortable. I've had clients that actually completely fell apart in tears because on the statement of information, we got down to this part. Oops, we got up to this part. And they had to talk about their former wife who was deceased. I mean, good God. But that's how it works, okay? So on our title policy, and it's one of those nuisance type things. Do we have to fill it out? Yes, you have to fill it out, and the sooner the better. So get those statement of informations in, and again, make sure it all jives. And let's just be clear. If there's something on the statement of information that you immediately catch that you know is a mistake, catch it now. We used this example 2 or 3 times in the last couple classes. You have, let's just keep it really simple. You have a buyer, okay? You believe that this buyer, just because of their age, they're very young. Are you married? No, I'm not married. You just assume that because they're so young, they've never been married, therefore they are what? They are single. Sally Smith, a single woman. Okay? So when our escrow instructions get drafted and everything gets drafted, Sally Smith is vesting as a single woman. The grant deed gets prepared. Sally Smith, single woman. Okay? Now she fills out the statement of information, and to your surprise, this 21-year-old girl has been married 3 times. Okay? Well, guess what? She is not a single woman anymore. She is Sally Smith, comma, an unmarried woman. Not the same. Okay? And now all the documents have to be changed. The grant deed has to be changed. The loan documents have to be changed. All of that stuff has to be changed. So if you find that type of a discrepancy or mistake, don't wait for escrow to catch it, because you know when they're going to catch it? They're going to catch it the day before you close escrow. And it's going to take you 3 days to fix it. Okay, on this particular prelim, pretty much everything from here down is boilerplate. I'm not going to go through this. Informational notes. It talks about they're collecting a lot of non-public personal information. They're not allowed to sell it on eBay. There's all sorts of laws and all sorts of nonsense that apply. Very important, especially that, you know, it wasn't that common, to be honest with you. And again, this prelim's, you know, several years old. It wasn't that common several years ago that a lot of our buyers were wiring in information into escrow to close. Now it's becoming pretty commonplace. I love it. Okay, but it will always have your wiring instructions on the prelim. Okay, so it's 5 o'clock at night. You're trying to get a deal closed. The buyer wants to set up a wire. They're gonna, which by the way, a lot of times they can do this online at home, right? Now your clients can do this right at home from their pleasure of their internet connection. But you call escrow, they're closed. You call title, they're closed. You now have to wait till the following morning to get the wiring information. Well, no, you don't. It's in the prelim.
That's the wiring to the title company.
Title. Yeah, but title and escrow, whoop. Most of the time, matter of fact, most escrow companies don't want you wiring money to escrow. They want you wiring it directly to title. Okay? But if you have a concern with that, you talk to your escrow, which by the way, if you're going to be wiring funds, don't wait till 5 o'clock at night to talk to your escrow officer. But you will find that most of the funds that are being sent to escrow in the form of a wire are not being sent to escrow. They're actually being sent to title, specifically the loans. Okay? It's very rare that Bank of America, when they said they funded a loan, they don't send that money to escrow. They send that money to title. Okay? Which is a lot of times why there's a delay in finding the where's the wire. Well, look in your bank. Well, escrow, who do we normally call to find out if the wire's hit? We normally call escrow. Guess who they're calling most of the time? Title. Okay? Now, are there some differences with that? You're 100% correct. Yes, a lot of escrow, especially you're dealing with Chicago Title / escrow. In that case, which by the way, we have our own escrow. We'd love you to support our escrow. But there's something to be said with doing business with the big boys. And specifically with First American Title / escrow. Because guess what? I mean, it's there. I mean, there's some benefit to that. Things tend to move a lot quicker. So anyway, you'll get your wiring information here if you need it. And again, we've got just a whole bunch of other stuff. I'm not going to go through the specifics of all of these particular things. They've got some notes, talks about the Alta policy, the da-da-da, it's a single family property, so on and so forth. You need, not that you can skip through all of this stuff, but this stuff you will find will be a heck of a lot more boilerplate than the main items, so to speak, in the first page. And then, of course, we have all of the legal stuff. This is the fine print, Exhibit B. This is basically all of your California law, insurance commissioner law. Okay, so we're going to do one more of these. Where I do my second one. And again, if you're not in the habit of reading these, this is going to save you money or it's going to cost you money. You choose. Okay, here is another title policy. Again, these are old. It doesn't matter the fact that it says 2004. They look exactly the same today as they did 7 years ago. Okay, so here's our borrowers. That's our buyer. Okay, what are we getting? We're getting a preliminary title report dated. Again, this title report is good at, forget about this date, by the way. This title report is good as of when?
February 9th.
February 9th, 2004. If something is recorded at any point after February 9th, 2004, this title report is no good. This is a little bit of a repeat from what we talked about because we're looking at the same stuff we looked at an hour ago. So, which is why it is important that your title companies are updating their prelims regularly. If you are in escrow, and you've been in escrow for 30, 60, 90 days, and you are now 3 days away from close of escrow, and you have jumped through every possible hoop that you could possibly jump through, you are ready to go, buyers are excited, sellers are excited, your commission is spent, and then you get a phone call from escrow / title officer that says, oh, a lien popped up, substandard condition, city of ABC. I want to know the definition of popped up. Now, if it popped up in the last couple of days, I'm going to say, ugh, that's bad luck. Okay? We're going to be delayed however long it takes us to clean up that lien. If they now tell me popped up was 35 days ago, happens all the time. When was it recorded? Well, it was recorded on February 14th. Well, what's the day today? Well, today's March 30th. We've been in escrow for 65, 70 days. We finally got it all ready to roll. And your title company that you've chosen is not regularly updating their prelims. And they do it at the very end. 99% of the time, that's not a big deal. In this particular case, well, it didn't just pop up. It popped up 60 days ago. You guys just updated your prelim today. You now cost me a week, or maybe kill the deal. Maybe that specific, the newest delay, could be the last nail in the coffin for that deal, and it's dead because your title company's not doing a good job. Okay? So you want to ask them that. How often are you guys updating these prelims? You know, and it might not be a bad idea whether you ask them that or not. You know that you're going to close a week from now or 2 weeks from now, and you've had one of these escrows that's maybe drug on a little bit longer, you've been in escrow for 60 days, you've been in escrow for 90 days. Put yourself, contact management program, a different class, have a little tickler in there, follow up with title to update prelim. Have that thing pop into your eyes every 2 weeks. Give them a call. Hey, looks like we're finally going to make this thing. We're about 2 weeks out. We're going to get one more thing cleared up on the loan. We got an extension. We're good to go. Do me a favor. Run an update on that prelim today. I don't want to be surprised by something the day before close of escrow. So anyway, it's only good through that day. A plat to be used with the order number. There's a plat map in here. That's what they're referring to on this. Okay, now this is going to look very similar. I'm going to go a little bit faster than I did in the last one because the information is basically the same. We've got, here's our escrow company, here's our escrow officer, here's our escrow number, here's our policy number. This is probably the escrow number, that's probably the prelim type of number. Again, it's telling us, just like in the old policy, the last policy we just looked at, this policy is good as of this day at 7:30 a.m. Anything that recorded, oh by the way, I said it's good as of today. It's really not good as of today. Because if something comes in and is recorded on February 9th at 11:30 a.m., it's not on here. Okay? So it's the day before. Same exact nonsense that was on the first prelim we looked at. All the goodies on there. All the exceptions on there. Okay? Now, does this look familiar to what we just saw before? A little bit different, but basically the same thing. What are we getting? The form of the policy of title insurance, again, contemplated, same exact language as in the first prelim. By this report is, in other words, this is not a title insurance policy. This is an application. We're contemplating giving you insurance. There's 2 boxes checked. The CALTA, California Land Title Association Standard Coverage. That is what? Remember, you were paying attention earlier? That is the owner's policy of title insurance. Page 2, allocation of cost, item 4, section C2. When you check buyer or seller, when you say pay for owner's title insurance policy, again, I know this is a repeat, but for those of you that were sleeping, this is what you're buying. So again, if your buyer says, what is this California Land Association title insurance, refer them to page 2 of the contract and says, we asked the seller to pay that for you. Title insurance covering the owner. Well, I see this isn't checked, and this isn't checked, and this isn't checked. Well, this is America Land Title Association. That's the ALTA policy. This is the CALTA policy. This is the ALTA A policy. Well, what is that? Well, again, we talked about this already, remember? Page 2, paragraph 4, C2. That's this little piece down here in parentheses that says, the buyer shall pay for any title insurance policy that insures the lender. Okay? The seller is paying to insure the owner, the buyer. The buyer is paying to insure the lender. That's the second part of the title insurance policy, and that is the CALTA policy. So this is a little repetitive. I've done 3 classes in the last 4 classes in the last 4 days. Contracts, where we talked about this, and partially what we talked about. It's a 4-hour class. If you haven't watched it, go back and watch it. One of the things we talked about was that, well, we talked about the whole thing, but we focused on this. Who's paying for that? If you cannot explain to your buyer that even though the seller box is checked, there's still a cost to the buyer, you're going to make a mistake because your buyers are going to say, wait a minute, why am I paying for this title stuff? Because the box says the seller's paying for it. The reason you're paying, Mr. and Mrs. Buyer, is because of this little sentence down here, which drives me mad. There should be a box right here that says buyer is going to pay for that. Check it. It gets rid of the confusion. So anyway, that's the that's the CALTA policy. This is the ALTA policy. So again, just like on the first prelim that we looked at, there it is. Okay, so you're getting our 2 types of coverage. We have our Schedule A. Look familiar? Schedule A is exactly like we talked about before. I'm telling you, you line up 10 different companies with 10 different title policies or prelims on the same property. They're all basically going to be formatted and look the same. Schedule A. This property is also fee. I'm not going to go back and explain that again. We already talked about that. Who owns the property? If this is not your seller, you got a problem. Or if there's somebody else that's your seller, wait a minute, I got Patricio, who the hell's Julie? Okay? Oh, well, Julie's my deceased wife. Oh, well, that's good, because you held title as joint tenants. Cool. It's a good thing. We'll talk about how you hold title later. But deceased wives, joint tenants, Patricio gets all of it. That's cool. We don't have to worry about that. Although we're probably going to need a death certificate and a few other things to prove that she's really dead. Now, by the way, if she is really dead, but there's no death certificate, are we going to close escrow? Nope.
No.
She just died 2 days ago. Crap. That's bad news all the way around, but guess what? We got a problem. Okay? Or she's missing. You know, there we go. We got
And you're
problems.
gonna wait 7 years.
And you might have to wait some time. Okay, so we got our sellers there. Schedule A, does this look familiar? Same as before. 2 different companies, 2 different prelims, same format. Schedule A is your legal description. Check the legal description on the prelim. Check the legal description on the escrow instructions. Make sure it's the same. Check the legal description on the grant deed. People type these things in, okay? People make mistakes. If it's wrong, catch it now. Be the professional. Be the one to save your deal and make it close on time, as opposed to what happens all the time. I have had, and again, this is, I guess, a poor reflection on me, but I have had countless number of escrows that have been delayed for a couple of days or a week because of a typo that nobody caught, including myself. We're ready to go. Oh, crud. We got the track numbers wrong, or something got transposed or something like that. And then guess who catches it? The lady who's paid to catch it before the document goes down to the title company. They literally just, you know, fine-tooth comb, go through every, oh crap, we made a typo.
Underwriter?
You need to be the one. Well, it wouldn't necessarily be well, it would be the underwriter at the title company, more than likely, or it could be someone at escrow. But normally who catches these mistakes are the title company, the title documents, because they're the one who has to insure it. You know, it's a little off topic, but you made me think of it. If you are in person or present when one of your clients is signing something that's notarized, okay, take a minute, take a good look at that notary stamp. Take a look at the stamp, take a look at the information, take a look at the dates, take a look at the signature. You guys want to be a notary? You know, go to a class on Saturday, you're a notary on Saturday afternoon, you get your stuff, you have no idea what the heck you're doing, okay? You know how many deals I've personally had delayed because the notary stamp was maybe just ever so much smudged, okay? Or the date was incomplete. Look at that stuff. And by the way, let's suppose you've got a notary and there's a big stamp right here and it's screwed up. It's obvious. Oh, yeah, guys, it didn't go on right. Well, stamp another one on there. Nothing wrong with that. You can have, I mean, it might look a little ugly. You can have, you know, the first one, there wasn't enough ink. You know, pop another one on there. Oh, that one got smudged. Well, pop another one on there. As long as one of them is good, now they might squawk about it, but if there's one that's good, they're going to take it. So, but anyway, look at that stuff. It's really important. It's going to save you guys a lot of time and headache down the road. Okay, Schedule B. Look familiar? We already have a Schedule B. Same exact format. Now again, this is a blessing and a curse. Because they're the same exact format, they're very easy to look at. So as you're flipping through the pages, your familiarity in looking at these things is like, oh, yep. So the good news is you know what to expect as you're flipping through the pages. The bad news is they tend to just all blur together. So take the time and read them. Okay, what's the very first thing that's always mentioned in the Schedule B? Taxes, okay? General and special, we already talked about that. This particular property has $1,800 worth of taxes. Just like on the first prelim we looked at, the first installment, the December installment has been paid. The April installment has not been paid. Open means unpaid, which by the way, you will see prelims that say unpaid. Don't say open, they'll say unpaid. Or delinquent, you might have years that are stacked on here. Okay. Another thing to keep in mind, especially if you're, well, not especially, but I guess especially if you're a listing agent, if you have and again I'm talking real sellers, I'm not necessarily talking short sales or REOs or what have you, but you have a real seller and you've done a fine line on the net sheet. The net sheet is perfect. You've got their mortgage balance right, you've got all of their goofy things on here, but they failed to mention to you that they haven't paid their property taxes for 4 years.
Oops.
Well, oops is right. Well, now your net sheet is going to be off by, in this case, $7,000 to $8,000.
Plus interest.
Okay, plus interest and penalties. So, if that's the case, you need to get on the horn immediately. Hey, Mr. and Mrs. Seller, I know you said you had to have $20,000 at close of escrow or this deal was not going to happen. You've been telling me that from day one. by miraculous intervention, we have an offer. I've given you a net sheet to the penny, and guess what? You're getting that $20,000, but what you failed to mention to me, you have $8,000 in unpaid property taxes. Oh, well, they've been impounded. Maybe they're right. Maybe there was a glitch. Most of the time they're not right. They're wrong. They haven't been paying. But at any rate, guess what happens before close of escrow? It gets resolved. They get paid. And if they are right, they have to prove it. So anyway, we've got our property taxes. Again, I'm not going to spend a lot of time because we already talked about that. Supplemental taxes, already talked about that. Same, just like the very first one we discussed. And what do we got down here? Unpaid. Okay, now, oops. Okay, now we're getting into, I think, wait a minute, I might have gone too far. Okay, we've got our supplemental taxes. We discussed that in the first prelim. Basically the exact same language. Okay, now in this particular case, now on item 3, we're getting into, we'll bring this up at the top. Okay, item 3, we're getting into easements. Just like on the first prelim, we now have an easement. And this particular one is for pole lines, conduits, or underground facilities. This easement goes back to March of 1955. Again, we've got the instrument number, which means it was recorded. And it's got all sorts of fun stuff. And guess what? It doesn't look like it gives us any specific footage, which by the way, is there a document that matches up with this easement? Let's go back to, well, maybe there's one on this one, but for a second, let's go back to the one we just looked at with the Edison and the GTE.
Yeah, it'd be the one that's recorded.
But if you actually want to physically see the document, then you say, give me instrument number, and then they will produce the actual easement. It could be 1 page, it could be 1,000 pages, but they'll actually produce it. So if it says there's an easement, but unlike on the other prelim, it was really nice. 6 feet affecting the front line, property line, 4 feet on either side. That's kind of nice. But if it doesn't say that, you may actually have to pull the easement to find out where the actual, what's affected. And this is kind of nice. Instrument number and book number of all official records cannot be located. Well, that could be a problem. And this is old stuff. That's very common. You know, a lot of these properties are old. We've been doing this for years and years and years. In this particular case, they're saying there cannot be located. That might be something that we need to talk about to our title company. We can't find it. Is that a problem? That could be a problem. Okay? And they may have to write around it, or if we're concerned that, wait a minute, there might be a big easement going along the back of the property and we want to use our swimming pool example, we might need to stop for a second and say, hey, wait a minute, we need to make sure that we can build that swimming pool on the back of that property. Okay? This is a continuation of, on the top of the next page. Let's take a minute on this actually. Okay, we got an easement for poles, lines, conduits, and undergrounds going back to March 4th of 1959. It's recorded, and apparently, without reading all the detail, there's a little bit of an issue. We're having trouble finding it. Now, we go to the top of the next page. And then we have this. Said easement has been transferred to the Fenmore Corporation by document recorded in 1983. So about 30 years later, something changed. Okay? And there's a new instrument in the official record, so on and so forth. Now I remember this specific property now that this comes to mind. Anybody want to take a guess what happened in 1983? Well, I'll tell you, this doesn't tell you. It truly would be a guess. What happened in 1983 is the Fenmore Corporation came in and bought a 40-acre parcel of land which had this easement on it, and they built 150 houses. Okay? So, common sense, and forget about common sense, the title company looked at the old easement that was recorded in the 50s and said, that's okay, because now we have a regular built-out subdivision that was built in 1983 by the Fenmore Corporation, and we all move forward and we're now comfortable that that old easement from the 50s has basically been taken care of by the builder who went in and built the subdivision now. Okay? But it has to make sense, and quite honestly, the people it has to make sense to are not us. It's going to be the title insurance companies. Okay, again, just like in the other prelim, this particular property has CC&Rs. We already talked about that. We took 10 minutes talking about CC&Rs. So there they are, and again, all of the reference, if any, to race, color, religion, sex, familial status, all that is all stricken and omitted. So that's we're all safe and good there. We've got more covenant conditions and restrictions. They've been updated, which, by the way, do these things get updated? They get updated all the time. Okay? Make sure you have the most current set of recorded documents. Okay, now we got another easement. Okay? This is a little more typical to what we saw on the last one. Okay? We've got an easement for public utilities, Southern California Edison, 1986, all streets, blah, blah, blah. 6 feet from the front, 4 feet from the side lot lines. Sound familiar? Same type of thing we just saw. Okay? Looks like we've got another easement going on to the top of the next page. More public utilities. Again, look familiar? General telephone, same type of thing. Pretty typical. Now we've got a covenant agreement. What do we got? Oh, we got something here from the Moreno Valley Unified School District. What did they do? Well, I don't know. Is it going to affect my sale? I don't know. Well, guess what? I better get a copy of it. What happened here? Again, does this name look familiar? That's our builder, that's our developer. Okay, we've got to find out what did the builder agree to do with the Moreno Valley Unified School District. And whatever they agreed to do, is it going to have an impact on my buyer's ability to do what they want to do? Okay? Well, we don't know. So get a copy of the agreement, see what the heck it says. Okay? Now we've got a deed of trust, just like before. It's, by the way, I'm going to skip around. It's dated in August. That's when the document was dated and most likely signed by the in this case, the owner. It wasn't recorded until 2 weeks later. Not that that matters, but just so you understand how that works. Again, is the loan in the name of the people that I think own the house? Take a look at it. Who's the trustee? Guild administration. Who's the beneficiary? Looks like another GMAC or Guild Mortgage. Okay, this is where we kind of talked about this. Guild Mortgage looks like they originated this loan, and they also have a trustee. We talked about this with the other one. I think the other one was Trustee Services of whatever. Yeah. Well, Guild Mortgage has Guild Administration Corp. acting as their trustee. Okay? Very typical stuff. All right? So, again, does this $113,000 loan make sense? Again, that's not the payoff. That was the amount of the loan when they originated back in 2003. Number 9, no policy will be issued under this order until we have furnished with a statement of information. Sound familiar? Same exact thing. Reconveyance fees and procedures. Number 10. These folks are basically talking about getting these loans reconveyed. There's some procedures in here. And supplemental lender. This was me. Some lender information. We're going to get an Alta policy. Oh, there's a name of our I thought it was a different address. I guess it's on Oakstone. If there's a different address up there on the top, I got a problem.
Where is that Oakstone quote? I never heard of it.
Oakstone, it's Moreno Valley, southeast corner.
Oh. Out by the college?
Redland?
Not quite that far. No. Not quite that far out. Again, we're going to get our Alta policy, wire information. Okay. Yeah. Here's our good funds rule. Going to send it into Union Bank again. Okay, pretty typical stuff. Exhibit A, legal description. Make sure it's right. We already discussed that. Plat map. There wasn't a plat map on the other one. This is pretty common. Everybody's somewhat accustomed to looking at these things. I've had at least 2 transactions that I can remember where there was a problem. Okay? No, I'm not selling the second house in. I'm selling the third house in. What the heck? What happened? It's very common when you look at these. This is impossible to see if you're watching on the camera, so have the document printed out. You'll have different numbers. I got a number 32 here and a number 11 here. One of them is going to be the lot number, and the other one's going to be the, I don't know, what's the other one going to be?
Last 2 of the API, I think.
Nah, I don't know. Anyway, I forget what they are, but they're 2 different numbers. Sometimes you have, these numbers are very similar to each other. One's a 12 and one's an 11. Human beings type this stuff in. Human beings make mistakes. I had a property, actually this is a good map for it. I had a property And this happens a lot, absolutely happens a lot. I had a property that was located on the corner, it was the corner of Paris and Fur, and normally when you go down the street, the property addresses are sequentially either getting higher or lower. You know, property 1, 3, 5, 7, 9, so on and so forth. On occasion, you'll go address 1, 3, 7, 5, 9. You're like, what just happened here? These properties are wrong. Somebody got the addresses in the wrong spot. That's not really true. When these lots and everything was recorded, at that point somebody made a mistake, and they put the address for number 5 on number 7 and number 7 on number 5. Well, what happens when that gets recorded? Well, guess what the address of that property now is? You're now out of sequence. I've had I don't know, probably 6 or 7 of those before, and I got to tell you, if you ever have a property like that, it causes problems. Okay, things get goofed up. Okay, especially with utility companies. It drives the utility companies crazy. So you got to be careful with that. Make sure you're selling the right property and you've got the right information on these houses. I think that's probably about the end. This is the insurance commissioner's rules and regulations that conform to CALTA and ALTA policies. So, long story short, okay, we're not going to go through the balance of this. So, with prelims. Just like anything else we're talking about, you've got to read the preliminary title report. So far, we've talked about going through the contract, getting the contract dialed in with your client, then taking those terms and conditions, making sure that the buyer side and the seller side jive. Then we went through our escrow instructions. The escrow instructions, do the escrow instructions match the contract? Is everything good on there? Now we've got a preliminary, which by the way, I'm telling you, agents, buyers, and sellers, they don't read the contracts, they don't read the escrow instructions, they don't read the preliminary title reports, buyers don't read loan documents, and it just causes problems. You need to read all of this stuff, okay? And again, if for no other reason, and this is not the right reason to do it, you will have a client that will read it, okay? And if they call you and ask you a reasonable question, and a reasonable question in my mind, I'm a consumer, I don't do this every day. Stephen, what is this and where is it in reference to the contract? I don't understand this. You need to be able to say, bam, this is the CALTA homeowner's title of policy insurance. It's on page 2 of the contract that you signed, item number 4, 3B. C. 2C, whatever. Okay?
4C2.
4C2. That's what it is. Oh, and what's this other piece? Oh, that's the piece that you're paying for, the ALTA policy. Remember, I explained that to you when we wrote the contract, that you would also be paying for a piece of the title insurance. Okay? Because this is the deal. If you don't know the answer to those questions, and it's a question that your client thinks you should, by the way, clients will ask you a lot of questions and you're not going to know the answer to them. And many of those questions, your client will think, okay, well that's perfectly reasonable. I was given a reasonable explanation and my agent told me they were going to get back to me, and I'm satisfied with my agent getting back to me with an answer to that. You will also be asked questions and you'll say, which is a good answer by the way, don't fake it if you don't know it. But you will be asked questions and their response may be, you know what, I'm a little embarrassed, I should know the answer to that. Give me 10 minutes, let me check it out and I'll give you a call back. That may work. But with some clients, that ain't going to work for them. You will have completely lost them. And not only will you, and by the way, if you lose them at that point, the rest of your transaction is going to be a nightmare. Because now they're going to challenge you on everything. Everything you say and do is now going to be in question. Okay? And then, are you ever going to get any more business from them again? Probably not. So, which is why I don't want to, the last thing I want to do is turn everybody in our office into professional students, meaning that you're afraid to do a deal, therefore all you ever do is go to classes and classes and classes because Lance said, don't embarrass yourself. Okay, well that's not what I'm saying, okay? You don't have to be perfect before you go out and do a deal. But quite honestly, if you just read through 99% of this stuff, you're going to pick it up on your own. And then, and again, every single deal, I got to tell you, that's probably not every single deal, but certainly 8 out of 10 transactions that we do, something new comes up. You learn something, okay? And clients will accept that. But it's the silly stuff that they want. It's the really silly stuff that they want. So, anyway, that's our prelim class. So, anybody got any questions before we run out of here?